Uh,
No,
I have the 2022 one. Page number 55 of this book,
yes,
chapter 5A. This is the rules governing applications for directions, orders, or writs under Article 220 of the Constitution of India. You'll have to skip to page 59, Rule 10.
yeah.
All questions arising for determination under these rules shall be decided ordinarily upon affidavits, but the court may direct that such question as it may consider necessary be decided on such other evidence as it may deem fit. Where the court orders that certain matters in controversy between the parties shall be decided on such evidence, the procedure prescribed in the Code of Civil Procedure 1908 for the trial of suits shall, for so far as applicable, be followed. Now, as your lordships are perhaps more aware than I am, insofar as civil law is concerned, there is a provision for commissions under section 75, and there are also under order 26, rule 10, your lordship. I am taking your lordships, rule 4A, your lordship. I apologize. Order 26, rule 4A. CPC to Singda, CPC to CPC.
Yes, tell me.
Lordships, I'm reading 4A, commission for examination of any person resident within the local limits of the jurisdiction of the court. Notwithstanding anything contained in these rules, the court, or any court,
No,
may,
no, madam.
Lordship,
Rules 4A
Lordship,
would not apply here. This will come within the ambit of Order 26, Rule 9.
Rule 9, Lordships. Like I said, you Lordship will be more aware of than I am. Perhaps, your lordship, perhaps in any suit in which the court deems a local investigation to be requisite for proper or the purpose of elucidating any matter in dispute, or for ascertaining the market value of any property or the amount of any necessary profits or damages for annual net profit, the court may issue a complaint in such person. Lordship, perhaps I stand corrected. I do not, because I am not a expert on civil law, your lordship, but yes, perhaps this is my limited understanding. 4A perhaps could also have
4A
applied.
will be only for the purpose of examining of one person. We are
Yes.
not concerned here, but here is the case. Because you see, otherwise the issuance of a commission is no problem. But who is going to pay the amount for the commission? That is the only
That is-
worry.
Lordship.
Yes, Mr. Gogoi, but you have to stay on that.
Regarding this matter, I have nothing to submit, madam. I leave it to your lordship.
No, you leave it to me.
They will
but,
appear.
well,
madam.
no, the thing is this.
Yes, they will appear.
What happens out here is this. Yes, this court can very well direct.
Yes.
This court cannot direct any other person. A person who may be having a knowledge about the medical knowledge or expertise in medical knowledge, he will be the best person to adjudicate that aspect of the matter.
Yes.
But why will he do it for free? And here is a case where there is a case against a particular the government.
Lordship.
So to appoint somebody under the working under the government would not be proper
Lordship.
for getting an individual or a non-biased opinion. I'm not saying that they would be biased, but then also not to have an opinion to the effect that these people are to the. So somebody has to be appointed. Who is going to pay for the charges? He'll be giving his time and hours out there, but who is going to pay for that? That is the only worry.
Lordship.
Like in cases pertaining to habeas corpus, those cases the court used to direct the district judge to decide and take up fact-finding inquiry and then report back.
My lord.
Those are done in that regard. But this is a case of where it will be something more like a trial. Although the rules of evidence may not apply, but why this court is thinking about this particular thing is because they are harping on the question that there has been some negligence.
Yeah.
This court taking into account that it being a 1 in a million case, as has been stated out there, it may not be possible on the basis of jurisdiction exercise under 226 to adjudicate that aspect of the matter.
Right.
This court can always, on the ground of right to life, to live with human dignity is another aspect by which only the minimum of the compensation can be paid.
Lordship.
But here is the otherwise the case out here. But if the rules of res ispa loquitur doesn't apply, then obviously this court can't give anything. But this court also can't look into the fact, see that this is a matter of 2014.
Minor.
And it has been pending, as the learned counsel for the petitioner said, that if this petition wouldn't have been admitted, then she would have definitely gone out there in the civil court and got.
Minor.
So that is the reason why this court wants. But who is going to pay the expenses for that particular? That is the only question now.
Minor.
Like if it is a dispute, if you see under Order 26 Rule 9, when a civil proceeding, then the proceeding, in that proceedings, parties are directed to
Yes.
pay the cost. Whoever wants this investigation, to
Minor.
pay the cost.
Right.
Or if it can be done through a civil nazir, it is done through the civil nazir, it can be done. But as of now, this aspect cannot be done by a official under this High Court,
Minor.
so that to do it for free of cost. And taking into account the medical evidence out here, it will be a person who has
Right.
been
Expertise in that.
expertise in that field to decide that.
Lordship, may I just submit one more aspect? Lordship, may perhaps be absolutely correct insofar as the appointment of the commission is concerned. But your Lordship will perhaps also appreciate the fact that 2014 to 2013, 11 years, almost 10 years running now, your Lordship, where is it that we are going to be able to find the evidence to prove a particular matter?
No, no.
Because the particular
You,
commission,
the facts otherwise are admitted.
yes, your Lordship.
Those facts are admitted, but as to whether on these facts, can it be said that there has been a negligence?
Lordship, may I also be allowed to, in that case, just once again refresh your Lordship's memory insofar as the negligence aspect of it. I will just show by way of affidavit as to how I had referred to this AFEI guidelines, your Lordship. In fact, yesterday I went through the guidelines extensively. Unfortunate as it is, the guidelines are very much there. But the what is the purpose of the guidelines is not, it is not absolutely.
No,
unclear.
therefore you have to show one
Lordship,
thing,
yes, your Lordship.
that if, let us assume that these guidelines are there,
Yes,
that because of the failure not to do in terms with the guidelines,
yes, your Lordship.
has it occasioned that this child has been inflicted with this problem?
So that is what I was trying to come to, that Lordship, that the guidelines per se deal with how to manage media. Unfortunate as it is, the guidelines have an extensive chapter as to how the media has to be addressed in case a viral infection has happened or an AEFI has happened. What should be the consequence of that? Unfortunate as it is, the guidelines are absolutely silent as to what should be the remedy for the person who has been infected or the person who's been affected by those things. The negligence, your Lordships, which your Lordships are trying to look at, is evident in the fact that till date, as per the AEFI guidelines, they are saying that the onus was on me to have identified it as an AEFI, which is absolutely incorrect. It is the onus was on the ANM at that point of time to have identified that this is an AEFI, to have reported it, filed an FIR, there's called a first information report, then proceed to the PIR, which is a preliminary investigation report, and thereafter submit a detailed investigation report. It is only after these three steps have been completed that the matter is thereafter referred to from the district level to the state level, from the state level to the national level. In one of their affidavits, the authorities are saying that it is a fit case to be sent to the National Advisory Committee for looking into the aspect of the matter. How are you planning to send it? You have not even done your homework. You have not identified whether a PIR or FIR was lodged. Even despite the fact that they have themselves brought in the question of FIR and the question of AEFI guidelines in their affidavit, they have not deemed it fit to file an FIR even till date. Who is going to verify the vaccine which was administered? Where are we going to find that batch from? In one of the affidavits, there is a loose mention of the fact that there were 4 other children who were administered vaccine from that same batch, but nothing happened to them. I have absolutely no qualms. I'm saying that this is a one in a rare case that the vaccine completely damaged my body. But perhaps the onus also lied on them to find out, to verify that fact at that particular moment. After 9.5 years, where are we going to find the needles from? Where are we going to find the vaccines from? Where are we going to prove that negligence was actually attributable?
But
The
why didn't you
negligence
make
has
that?
to-
Why didn't you make that vaccine party out there? Where is your pleadings out there to the effect that the vaccine should have been made? In 2014 also, you should have made it.
Perhaps, Your Lordship,
Then-
perhaps that is the disclaimer on that
Then-
a fault on my part, but it was not a
But
civil.
madam,
but
kindly,
Lordship, this is not a civil
kindly
court. I was-
understand one thing. If this court has to grant damages to them, against them, then this court has to come to a finding that there has been a negligence which has resulted in this particular situation of the child.
Lordship, with all utmost humility, Your Lordship, I had placed before Your Lordship the judgment of Upahar Tragedy Cinema Hall. There in paragraph 97 and 98, Your Lordship, there's a categorical finding by the Honorable Apex Court, which is a consensus finding by both the judges, that even if there is no negligence attributable, if it is a question of personal life and liberty, Article 21, then the court has the power to go into this thing and give compensation
For what?
for even if negligence, because the liberty, life and liberty has been affected.
No,
For that
then what compensation has been awarded by that court?
Lordships, it has been,
Let me follow that judgment and give you that amount of compensation.
Lordships, I would say that if that is the question, then I have no difficulty, because what I'm asking for is just the basic. I'm not asking anything extra from this honorable court. I'm only asking what is my entitlement as per law. A constitutional tort has been committed, Your Lordships. I'm not. Let me also make myself clear that I am not averse to Your Lordships in any manner.
No,
or
madam,
disagreeable.
Kindly
to the
appreciate
commission being
one
appointed.
thing. Kindly appreciate one thing.
Lordships.
In various other cases, just for example, in the case of Nilabati Behera and all these cases,
Yes, that was the
there has
genesis.
been a case of negligence.
Correct.
Therefore, the pass order to the
Correct.
if a person dies in the custody, you can very well import the concept of negligence, taking into account the very aspect of res est locator. That is what I say.
Thing speaks for itself. Absolutely, Your
But
Lordship.
here is a case whether on the facts, can you say that if it was brought on, the decision was taken on 14th and not on 16th? Can you say that it would have changed the situation? That is the word. Because you are saying that they have not followed the guideline. Guideline for what? For the purpose of giving an FIR, for following it up to that particular level. These 2 days, which was the difference in which they have not taken into consideration, has it resulted in such a case that this has happened?
That
Give me
how-
that evidence. That is the
is
only
what,
finding
Your
which I
Lordship,
want.
Where we would have found that evidence? Through the guidelines? That is what I was trying to
No,
tell
no,
you.
does
Lordship,
the
that
guidelines
itself are
say-
silent as
Does
to
the
what-
guideline say, no, some medical evidence has to be placed or anything has to be placed to the effect that yes, if it was taken up on 14th itself, or these would have been followed, then it would have not resulted in this aspect. That is the only thing which I want. Otherwise, on what basis can I give you any other damages? Negligence otherwise has to be proved. That is the law.
No, Lordship, that is what I was trying to tell you, Lordship, that in the case of Upahar tragedy, negligence is the word which has been done away with. That in the case of an article where Article 21 is concerned, each individual life is important. And if it's a rarest of the rare case, then even if negligence is not proved, even then the court has the power to grant compensation. That is what my humble submission for your Lordship is. My paragraph 97 and 98 of that particular judgment,
Show me that.
which has also been relied upon recently in another judgment, Lordship. 2011 14 SCC. Page 481. So I'm reading the relevant portion from page 538.
Yeah.
538. Now, if your Lordship will see that it is a judgment rendered by Justice Radhakrishnan. Page 538. If your Lordship will- paragraph number 80, your Lordship.
Hello?
80. I'm starting with 80. 80.
Yes.
We are primarily concerned with the powers of the constitutional courts in entertaining such monetary claims raised by the
Para
victims.
80.
80. Does it not match?
Yes.
We are primarily concerned with the powers of the constitutional courts in entertaining such monetary claims raised by the victims against the violation of statutory provisions by the licensing authorities, licensees, and other affecting the fundamental rights guaranteed to them under the Constitution. The constitutional courts in such situations are expected to vindicate the parties constitutionally, compensate them for the resulting harm, and also to deter future misconduct. The constitutional courts seldom exercise their constitutional powers to examine a claim for compensation merely due to violation of some statutory provisions resulting in monetary loss to the claimants. Most of these cases in which courts have exercised their constitutional powers are when there is intense, serious violation of personal liberty, right to life, or violation of human rights. Thereafter, Your Lordships, in all the rest of the paragraphs, the Honorable Apex Court has discussed the various case laws insofar as UK, USA, also in India, including Nilabati Behra, as Your Lordships had just refined. Thereafter, Your Lordships will kindly skip to paragraph 95. Specific reference may be made to the decision of this court in Nilabati Behra, which Your Lordship had just said. I'm reading paragraph 17 quoted therein. A claim in public law for compensation for contravention of human rights and fundamental freedoms, the protection of which is guaranteed in the Constitution, is an acknowledged remedy for enforcement and protection of such rights. And such a claim based on strict liability may be resorting to a constitutional remedy provided for the enforcement of a fundamental right, is distinct from and in addition to the remedy in private law for damages for the tort resulting from the contravention of the fundamental right. Thereafter, Your Lordships, I'm skipping the rest of the portion. Paragraph 96. Courts have held
So that is what this court was
No, no,
opining
yes,
initially.
This was
Now,
Nilabati Behra.
I am saying that you get a minimum
Lordship,
wage as compensation and giving you liberty to go to the approach the civil court.
Lordship, this is Nilabati Behra. If you will just read forward.
Yeah.
Paragraph 96. Courts have held that due to the action or inaction of the state or its officers, if the fundamental rights of a citizen are infringed, then the liability of the states, its officials, and instrumentalities is strict. The claim raised for compensation in such a case is not a private law claim for damages under which the damages are recoverable are large. The claim made for compensation in public law is for compensating the claimants for deprivation of life and personal liberty, which has nothing to do with the claim in private law, claim in tort in an ordinary civil court. This court in so-and-so extended the principle to cover public utilities like the railways, electricity, so-and-so, and local bodies, which may be social utility undertakings not working for private profit. In Prabhakaran, a woman fell on a railway track and was fatally run over, and her husband demanded compensation. The railways argued that she was negligent as she tried to board a moving train. Rejecting the play of the railways, this court held that her contributory negligence should not be considered in such untoward incidents. The railways has strict liability. A strict liability in torts, private or constitutional, do not call for a finding of intent or negligence. In such a case, the highest degree of care is expected from the private and public bodies, especially when the conduct causes physical injury or harm to persons. The question as to whether the law imposes a strict liability on the state and its officials primarily depends upon the purpose and object of the legislation as well. When activities are hazardous and if they are inherently dangerous, the statute expects the highest degree of care, and if someone is injured because of such activities, the state and its officials are liable, even if they could establish that there was no negligence and that it was not intentional. This is what I'm placing before your lordships. Public safety legislation.
Now, are you therefore saying that the activity of giving vaccine is hazardous?
It's a public health, it's a public safety.
No, is it hazardous?
It is not hazardous, but your
Then?
should also note the
You
word.
see, this concept have been
which
developed
makes
from
something-
this Bhopal Grass tragedy about absolute liability. This is a developing of that concept that irrespective of negligence being shown or not, it is absolute. They have to pay if there's something happens. Then
Lordship, if I may just read the next paragraph as well. Public safety legislations generally fall in that category of breach of statutory duty by a public authority. To decide whether the breach is actionable, the court must generally look at the statute and its provisions and determine whether legislature in its wisdom intended to give rise to a cause of action and damages and whether the claimant is intended to be protected. Next paragraph. But in a case where life and personal liberty have been violated, the absence of any statutory provision for compensation in the statute is of no consequence. Right to life guaranteed under Article 21 of the Constitution of India is the most sacred right preserved and protected under the Constitution, violation of which is always actionable, and there is no necessity of statutory provision as such for preserving that right. Article 21 of the Constitution of India has to be read into all public safety statutes, since the prime object of public safety legislation is to protect the individual and to compensate him for the loss suffered. Duty of care expected from the state or its officials functioning under the public safety legislation is therefore very high compared to the statutory powers and supervision expected from the officers functioning under the statutes like the Companies Act, the Cooperative Societies Act, and such similar legislation. Thereafter, Your Lordship, paragraph 99, the measure of damages. I'm not even going to that is about the measure of damages, which I will completely leave to Your Lordship. My humble
No,
submission to
measure
Your
of
Lordship.
damage is the most important thing.
No, that is Your Lordship's discretion. I do
No,
not.
that is not my
Yes,
discussion.
Your Lordship, that it is.
I am having the problem not because of other things. The only reason why I am having this problem for having a medical opinion on that aspect of the matter is that what is the measure of damages? How do this court come up with a measure of damages without a finding of negligence?
Then Your Lordship will read paragraph 99 and
Yes.
100. The law is well settled that a constitutional court can award monetary compensation against the state and its officials for its failure to safeguard fundamental rights of citizens. But there is no system or method to measure the damages caused in such situations. Quite often, the courts have a difficult task in determining damages in various fact situations, which is what is happening to Your Lordships. The yardsticks normally adopted for determining the compensation payable in private tort claims are not as such applicable when a constitutional court determines the compensation in cases where there is violation of fundamental rights guaranteed to its citizens. In D.K. Basu versus State of West Bengal, the constitution bench of this court held that there is no straitjacket formula for computation of damages, and we find that there is no uniformity or yardstick followed in awarding damages for violation of fundamental rights. In Rudul Shah, this court used the terminology palliative for measuring the damages, and the formula ad hoc was applied. In Sebastian Hongre case, the expression used by this court for determining the monetary compensation was exemplary cost, and the formula adopted was punitive. In Bhim Singh, the expression used by the court was compensation, and the method adopted was tortious formula. Again, in D.K. Basu, the expression used by this court for determining the compensation was monetary compensation. This formula adopted was cost to cost method. Courts have not therefore adopted a uniform criteria since no statutory formula has been laid down. Thereafter, Your Lordship, paragraph 103, of course, 101 talks about what are the headings under which the court can look into on constitutional torts. And 103, legal liability in damages exists solely as a remedy out of private law action in tort, which is generally time consuming and expensive. And hence, when fundamental rights are violated, the claimants prefer to approach constitutional courts for speedy remedy. The constitutional courts, of course, shall invoke their jurisdiction only in extraordinary circumstances when serious injury has been caused due to violation of fundamental rights, especially under Article 21 of the Constitution of India. In such circumstances, the court can invoke its own methods depending upon the facts and circumstances of the case.
Now kindly come to paragraph 12. Let's see the acts and omissions therein.
Lordship, I may also point out that there are two aspects of the judgment, one that by Justice Ravindran and one by Justice Radhakrishnan. Where I had started at paragraph 80, if your Lordship will see, before.
That is partly disagreeing.
No, there is an asterisk marks behind the past partly
No,
disagreeing.
no, it
No,
has
Your
been,
Lordship will kindly note the
it has
asterisk.
been stated out here as partly disagreeing.
Lordship, the asterisk marks after partly disagreeing has been explained at the bottom. Your Lordship will kindly note that. That is exactly what I wanted to point it.
It's
point
okay,
out.
but kindly
No,
see,
but
no,
as to
why
the
I'm
set-
saying about the facts, kindly see, paragraph 12.
Lordship, no, paragraph 12, I absolutely agree with
No,
you
no,
that
you
this
see,
was-
kindly see this.
Yes,
Paragraph 12, the last of the paragraph, the connecting wires should be crimping and not being hammering. The negligence on the part of the DVV in maintaining the transformers and the repairs led to the root cause of the incident, namely the starting of the fire.
correct, Your Lordship, absolutely. This was a case
What
where
this court wants from
where-
you is only one thing. That is, this not reporting of this AFL or whatever may be is the root cause for this incident has happened. That is the only thing this
And
court wants.
The only
show
available
me that.
guidelines for that is the AEFI guidelines, Your Honor.
Huh?
Which the only available.
That is what,
guidelines-
if the AFL guidelines would have been followed, then the question would have been different. That is the only thing which I want.
Now, how do I am not a medical personnel, Your Honor, and this is not a claim in tort.
That is what this
This is not
court
a claim in
wants.
tort, Your Honor.
No,
My only
madam,
submission
that
is
is, that is the reason why this court wants, taking into account that the matter has been pending out here from 2014. For only one thing to you, so that you can prove it to that effect that this is. Otherwise, for me to give other things which have been given out here, what, let us see what is the amount being given out here. Look out here at page 76.5, paragraph 76.5. The compensation awarded by the High Court in the case of death is reduced from 18 lakhs to 10 lakhs in the case of
Correct.
ages of more than 20 years and 15 years to 7.5 lakhs in the case of 20 years.
Absolutely.
This is with the basis of finding out that there is a negligence.
Lordships. This is
The what do you call, let us use the term as conquering opinion. The conquering opinion does not deal with this aspect of the matter.
Lordship, that is what I wanted to point out, that the other part has also been signed by Justice Ravindran. In that asterisk mark, the certified copy, it's that asterisk mark states, paragraph 80, Your Lordships. KVS Radhakrishnan partly disagreeing, there's an asterisk there. The asterisk says, as per the certified copy, this opinion is also signed by Justice Ravindran, which could only mean that this is also a consensus opinion, if it has been signed by him.
Yeah.
And thereafter, after having attributed negligence to the authorities under the particular facts of that particular case, the courts have gone forward and have developed the concept of constitutional torts in paragraph 98, 99, and 100, if I may say so. Thereafter, they have come to this thing that if in case it is a breach of the provisions of Article 21 of the Constitution of India, even negligence need not be proved, because in public safety legislations, the onus on the state authorities is extremely high, that they will take the utmost care in such things. Therefore, Your Lordships, in considering the fact that I'm going to repeat that particular line, the state and its officials are liable even if they could establish that there was no negligence and that it is not intentional. Even in such cases, in a rarest of rare cases, when Article 21 has been violated, Your Lordship may go into the matter and thereafter award compensation. That is what I was trying to tell Your Lordship, that the law has, the Honorable Court has deemed it fit in the particular facts and
But
circumstances
how
of
can I
that
award
case.
compensation in the line which you are asking? Tell me, how can I give that unless there is a question of negligence?
There is that.
You see, kindly giving a damage in the form of a constitutional court is on a different pedestal. Yes, you are entitled to. I may say that, okay, not in the form of minimum wages, but taking into account the minimum wages, give them 20 lakhs or whatever may be. That is another aspect of the matter. But how do I give you any other aspect which you are otherwise entitled to? Therefore, I say that let me give you whatever it is as in terms of constitutional court and giving you the liberty to approach the civil court. That is what I say. Then you say that why I have come from 2014 and the matter was tendered.
Not the efforts to go to another court and fight this out.
That is the reason
before your
why
lordships, I am
this
at your
court
lordship's
thought
mercy.
of that better off appoint a commissioner.
Then in that case, Your Lordship would also perhaps like to rely on the medical board examination report, which is before Your Lordships, which was by way of judicial orders. I was made to appear before a medical board, duly constituted by the orders of this honorable court, and that board has come to the finding that it was a post ADAM, that is acute disseminated encephalomyelitis. That could only perhaps be because the purpose of what Your Lordships are asking to have the commission for is perhaps already answered in that particular medical board examination. However, like I said, I'm not disagreeing
No,
with
that
your
but in that examination, whatever has been stated
lordship.
is 1 in a million.
Yes,
Then if it is a 1 in a million, then how can you import the negligence upon them?
lordship. If 1 in a million, then negligence need not even be proved. That is what paragraph 81, 98 and 99 are all about. But in a case, paragraph 99.
No, therefore, are you saying that whenever it is the duty of the authority out here to give vaccine out there, there is an absolute liability upon them if they do, or responsibility is
Even in the
such
co-
that if something happens,
Even in the
this court
COVID
has
time,
to award damages.
Lordships, even for the COVID vaccine,
Yes,
Lordships are aware that the compensation has been granted to people who have died because of the vaccine.
where?
And under the, if I'm not correct, 1 lakh sum for the BPL, this thing, if I'm not mistaken, correct me if I'm wrong, Buddha, am I wrong? But to my limited knowledge, for those BPL families whose patients have died because of COVID, a compensation of 1 lakh rupees has been awarded by the government.
You won 1 lakh?
No, Your Lordship.
Then?
I'm a 1 in a million.
They will be
I'm
happy.
in a 1 in a million case.
Oh.
And I have walked through the corridors of this court for 9 years. And I was a completely healthy, happy baby. Now I am a 100% disability, Your Lordships. Am I not entitled to something?
Yeah, definitely. This court has said
Then
that this court is going to give you something.
then
But
I'm
can,
absolutely at
but
your
should I
mercy.
not, should I say that you are not entitled for other things, and thereby give you the liberty to approach the civil court for all other claims which you are having?
I do not have any other claims, Your Lordship.
No, no,
I
you
know, Your
have other
Lordships. No, no.
claims.
I have only made a summative chart before Your Lordships, considering the entire context of the matter and considering Ayush and the other judgment where they were
No,
taking
that is
heads
why,
and
that,
this-
no, that is why in Ayush and all these things, there has been a adjudication on merits, on the facts. Yes, this has resulted in this. And therefore, there was a negligence on the part on which they are entitled to. Without that finding out there, how do I give you the others?
Lordships, had it been an MSCT case, I would have been easily be able to gone to the tribunal and prove it up, absolutely, right? Because there is a particular statute which by which
In
you
lighter
also-
vein, madam,
But in the
if a
instant
person
case-
dies from a plane accident, he gets less. And if a person dies with a car accident, he gets more. This is the law.
Lordship, that apart,
No, yes. The
Absolutely correct.
reason why
No,
it is
but-
because of the Aircraft Act have not been amended, or all these things have not happened by which the compensation has been put in that level. But if you
Lordship,
apply the Motor Vehicles Act
where
and
is
with
this-
the multipliers and all the law which has been declared, therefore you get a higher compensation.
Now, where is the law insofar as a person who has suffered a vaccine reaction? Where is the law with that? The only statutory authority which we can rely upon is perhaps the guidelines which they have in the AEFI guidelines. Now, if their guidelines themselves are silent about the onus, what can I legislate before the court, or what can I do? I can only place the AFEI guidelines. I can only point out the lacuna which have occurred insofar as the action of the authorities is concerned of not having done what was required to have been done. Thereafter, what happens had that been done? What would have happened?
Only one question, therefore,
question,
madam, is
Lordship,
as
even
to whether if it would have been done, it would have changed the course.
that has to be specific in the guidelines. Where how can I say that with the guidelines being silent
No,
about that?
for not lodging
How
an
can I-
FIR, are
how
you
can I
going to
say
say that the change in the circumstances of the child?
Perhaps it might have been completely, had they identified it that this is an AEFI and referred me to medical college immediately on 15th itself instead of 16th. Perhaps there might have been some change.
So that is
Perhaps
what.
I suffered 5
So
seizures.
should
on
this court
15th of-
go on the question of assumption and
I-
presumptions?
Lordship,
and
therefore
give
I'm
you a-
saying
yeah.
their guidelines itself are silent. Even if your lordship appoints a commission, how will the commission hold that there was negligence because the guidelines were not followed, because the guidelines themselves are silent?
No, not on the question of guidelines. It is only on the question as to whether these 2 days, which had made the difference, would have changed the position.
Then I leave it to your lordship, because I do not, I certainly do not have the evidence to prove that, because there is no evidence.
No,
in
the evidence is
statutes
clear that on
available,
14th, the child was brought,
lordship.
the
Vaccine.
child was given the vaccine, and on 16th, the child was again sent to the hospital. So in
15th, I
between
took her- 15th, I took her back for a checkup. They administered some things to me and sent me back. And in that process, I suffered 5 seizures. 16th, I took her back. That is when from Mangoldai, I was referred to the GMC. 16/11, yes. Another thing which I found out was that in 16/11, no beds were available in the pediatric intensive care unit, PICU. And so therefore, I was kept in a normal general ward. It is only thereafter on 17/11 that I was admitted to the PICU. If that helps a lot.
So if
That
would that have changed the position?
How can I say that? how can I address your lordship on that particular issue unless I was a doctor myself. Now, if your lordship, that's what I'm saying. I'm not disagreeing with your lordships that your lordship
And-
wants to
and,
appoint a commission.
And I'm also only versed in law, not in any done any MBBS on that.
I'll leave it to your lordship. I tried to convince your lordship as much as I possibly could, but I have no
Yes, Mr.
disagreement
Gogoi.
insofar as appointing a commission is concerned. I have no disagreement with that.
My lord, as lordship has already stated, it has not been proved that, my lord, because of some negligence, my lord, of the authorities. My lord, this thing has happened to the daughter of the petitioner, that she is now suffering. Otherwise, my lord, if some compensation is given because of whatever she is suffering now, that, my lord, we have already said it in affidavit and all, my lord, that it is going to, my lord, support her. But not, my lord, taking the, my lord, blame that, my lord, because of us, my lord, this has happened.
And what is the present minimum wages?
Minimum wages, my lord. Yeah.
You have the notification of minimum wages. I think you
I have
filed
an
it somewhere
It's in my affidavit
in
on
some
21/4,
affidavit. Hey,
2022.
affidavit, no?
One moment, if this is the one or the other. No, it is not. I would have-
Which one?
Watch it, just one moment. Oh, yes, affidavit dated 21/4/2022. It's an additional affidavit. Annexure A5, page 25.
Uh, 26/4? No.
No, 21/4/2022. 26/4, I think is their affidavit.
21/4.
Oh,
The affidavit is
one?
dated, my lord,
Additional
20th of
it is an
April.
additional
Annexure
affidavit.
A5?
Page 25, your lordship.
Annexure
A5,
A5?
yes, your lordship. Page 26 is the effective portion. Unskilled workers, wages per month is 9246.
And every 5 years this changes,
I'm not aware.
isn't it, Mr. Gogoi?
My lord,
It
Yes.
changes every 5 years.
the revision part, my lord.
Do we still have the Code of Wages Act? No. We still are into this minimum wages act.
Yes, sir.
Minimum wages act. I think section 5 says, 5(2) says every 5 years. Anyway. So it will be difficult on your part if permission is given.
Lordships, I do not, because I do not have any witnesses, and after 9 years, their witnesses.
No,
know
no,
what
on
is being
these,
said.
you see,
On these facts, okay,
these facts are true. 14
15, 16.
is the vaccine. 15th you have gone, there were 5 seizures. These are all matters of record. And then on 16th, you were put in a general ward. 17th, you were put to the PSU.
Yes.
Would these have changed the course of events? Thereby, yes, a person immediately, just for example, a person has a heart attack. The moment you give them a particular medicine out there,
Revive.
he may revive or he may not have this problem. And if a person, if he is not given that particular medicine immediately, the arrest, the cardiac arrest may have, may be fatal. So you don't want to.
No, I am absolutely completely not in disagreement with it. I'm leaving it to your lordship. Your lordship feel that by a commission, perhaps this fact is
Only that.
verified.
I don't
have
want
no
anything
qualms.
else.
I
Only
have
that
no
aspect.
qualms, your lordship.
If that is comes out,
My
if this
only-
should have changed, because you see, you are also say that you can't say as to it would have changed the position. But if we have some medical opinion to that effect, yes, it would have changed. And
That's what I was trying to tell you.
then
Lordship, that
wouldn't it
perhaps
be
had
better?
they registered the FIR, the PIR, and the DIR, perhaps on the basis of that, we could have come to the finding that had they done this,
Only to
perhaps
that,
it
this
might have
period.
got-
Other remaining other things are different.
Then your lordship will kindly quantify or qualify the entire terms of reference for the commission, and thereafter upon that can be my only humble submission. So that the question of cross-examination, examination of witnesses.
And
does
whom
not
do you propose?
I do not know whom they might bring.
No, no. Find out
And-
the person concerned whom this court to appoint as a commissioner.
Lordship, that would depend upon the medical profession. I mean, which doctor might be the. I'm sure a neurologist might be important.
Hmm?
Or
A neurologist, a person who had been earlier the principal or head of the department of this one,
also a pediatric doctor,
which is
would be
not
very essential.
presently attached with the government. I don't want it to be
Retired one,
government because they need to be should look fair. Also.
Lordship, also a pediatric person, because a pediatrics is a separate branch altogether. So
Oh,
a
okay.
pediatrician along with the
You
neurologist.
can have one, I think. A person who is nowadays you have a lot of other people. A person we never heard at one point of time a person in geriatric medicine. Nowadays you have a geriatric medicine, which is more specialized.
Pediatric medicine. Lordship, pediatric is
Earlier,
a separate branch.
People
Any
who
doctor
were
that
used to
your
be 65 or 70, they used to go to the same doctor.
lordship-
Nowadays, these people keeps on going to the doctor with geriatric medicine specialized.
just like us, we have several branches of law now, which were not there earlier. But yes, the fact remains that any neurologist will not give an opinion without a pediatrician. That is absolutely correct. Because when I was trying to get the opinion of these neurologists, they immediately referred me to a pediatrics. At one point of time, you had to find that get me the medical literature on this. So I had tried to talk to doctors about it. And when I tried to talk to a neurologist, he said the person concerned would be a pediatric because the child is yet to complete 15 years of age. So only a pediatric doctor would be the right person to be absolutely judged. And in fact, she was admitted in the pediatric ward. One doctor, Abhinandan Das, was the one who looked after her at that point of time. So who is a pediatric,
Because we also have to take his consent also.
whoever the doctor is.
Yeah.
If we appoint somebody, we have to take his consent also. Because if he says that it becomes difficult.
Yeah.
Because you have to also give him the secretarial assistance. Then in
the
that
expense
regard,
part will come.
hmm,
The expense part will come.
the expense, the state has to bear that.
Well, we'll-
Huh? The state has to bear that. We'll have it next Tuesday. You just, both of you just search a person concerned.
Lordship.
If it is a principal or head of the department of pediatrics who is qualified out there,
Lot.
it would be better
Neuro and
Neuro. having a neuro knowledge, because this will also have a neuro thing, because a pure pediatrician may not be knowing this. Would it be knowing?
I was referred back to the
Then,
pediatrician.
madam,
I have
you
placed
keep
that.
you whenever we put in any medical questions, you say that you have no
Lordship, I have
knowledge,
had the pleasure of
and you
raising
try
two
to
kids
test the
myself.
knowledge of this court.
Unfortunate as it is, Lordship will find out that the neurologist will tell your Lordship that his opinion would not matter. A pediatrician
Mr.
would be
Gogoi,
required.
Whomever we appoint, the state has to provide the expenditure. That you.
Lordships are looking for a private doctor or a person.
Whoever it is,
Whoever it is.
but you see what is necessary for him. He has to be given some remuneration for whatever work he does. One. And number two is he has to be given the secretarial assistance and a place where he can hold the meeting, hold the thing.
Lot.
We'll ask him to do it as soon as possible. But that person also has to be free. So have a word with both of you. Have a word and talk to a person if we can, so that I can appoint you. Let the matter be taken up for further hearing on next Tuesday.
Deep privilege.
Item number 2, part heard.
Yes, Mr. Goswami,
My lord,
you are
my lord,
still
as per,
objecting?
the direction of your lordship, my lord, I file an additional affidavit, my lord.
Yes,
My lord, annexing some documents, my lord,
where?
which my lord shows, my lord. It is, my lord, at page annexer 1, my lord, starting from page 259, my lord,
No, first let us read your additional affidavit.
my lord.
Yeah, this was filed on 27th of May 2022.
No, my lord. It is filed on, my lord, 1st of March, my lord,
1st of March
23,
2023.
my lord.
Okay, what does it say? Who is he?
My lord,
I'm the chief engineer, so and
my lord, respondent number 4, my lord.
file the present claiming reimbursement of the Kutka on differential amount. Now let us read paragraph 4. What do you say mean by that?
My lord. That the deponent access that from the annexer 1 document, it has been clearly established that the petitioner is getting ITC, and hence the railway is not required to reimburse the tax GST to the petitioner after coming of GST, that is after 1/7/2017. The petitioner is eligible for input tax credit ITC in respect of goods and service used as input in the execution of works contract. Input tax credit under section 17(5)(c) and 17(5)(d) will not apply to the petitioner, as his output is the works contract service. Hence, the petitioner who is getting ITC is rightly getting it. The instruction submitted by the GST department.
It's okay. But
It's-
now let us see. You are saying that the petitioner is eligible for input tax credit in respect of goods and services used as input in execution of work contract.
My lord. My lord, actually,
What
at
is
that, my
the
lord, that
basis
two
to
lines, my
say
lord,
that?
I have taken it, my lord, from the decision of my lord.
No,
my lord,
Mr. Goswami, don't go by the
lord.
petition. Let us see from the law.
My lord.
Where is the law?
Yes, my lord. In
Yes,
law
yes, yes.
also, my lord,
Yeah.
lordship will find, my lord, 17(5)(d),
Please
my
stay.
lord.
I forgot. Yes, 17.
17(5)(d).
You are also here only say that input carrying under section 17(5)(c) and 5 will not apply to the petitioner
My
in the
lord.
next line.
Yes, my lord.
And then why, on what basis is
My
he
lord, from my
entitled to
lord,
the
B, my lord, it
ITC?
refers, my lord, in which case, my lord, in this case, my lord,
Ah,
it is, if he is, my lord, applying it, my lord, for his own purpose, my lord, then, my lord, ITC is not available. Own purpose, my lord. But my lord, this is for supply to a third party, my lord.
Where is it?
Good.
It
my
is
lord,
not
the-
supplied to a third party.
Well,
It
third
is
party.
in, if it is done in execution of a works contract.
my lord, my lord, even then also probably, my lord.
No,
Lordship may kindly
Mr. Goswami, kindly don't come on the question of probability.
my lord.
I had a lot of probability in the earlier matter.
Yes, my lord.
Yes.
I have
Now
seen, my lord.
let us
I
get
have
on to
seen,
the
my lord.
point.
Good, my lord, may I read, my lord?
Yes,
Please, my lord.
Mr. Sahu, why you are absent when the matter is called? And where's your friend?
Actually, we got it accept my notice. At that about it was fixed for 21st.
No, it was fixed today. The learned counsel on the last occasion had stated that. Anyways, where's the other side?
Because I talked to him,
Yes.
he also, without, he was in the impression that only 21st. And if possible.
The sad part is that matter doesn't leave me. That matter, I didn't make it parted. One day I made it parted, I left it out, and thereafter the matter still keeps on coming back to me. And after reserving the judgment, and I was about to deliver the judgment. In fact, 75% of the judgment was almost ready. I was only, because I had taken into account another two judgments, Surendra Pal and all, Surendra Soni. That is another judgment I have taken into account of Justice Chandrachud. Everything I have taken. Then he comes up with Shyamala and gives the judgment. Now nobody's, other side is nowhere, must have become already frustrated because of your attempts.
So on 21st, he will also come.
No, why should I keep the matter any further with me? It is spoken to us. Na? Item number 57. As none has appeared on behalf of the petitioner as well as the respondent. So let the matter be listed in the usual.
Because I have appeared.
You have appeared now when I called you. Okay. As the petitioner has already only represented, but the respondents have not represented on twice. Let the matter be listed in the usual course. Giving it. Yes.
My lord, my lord, this section says, my lord, 17(5)(d), my lord.
But you say 17(5)(d) doesn't apply to the petitioner.
Yes, because it is not, it is not talking about the petitioner, my lord.
Both
It's not
received
talking
by
about the petitioner,
taxable
my lord.
person for construction of immovable property other than plant or machinery on its own
Oh,
account.
on his own account, my lord, on his own account. That
including
is the,
where
my lord.
goods or air are used in furtherance, in course or furtherance of business for the purpose of T&D, the expression construction includes reconstruction, renovation, addition or alteration of to the extent to the extent.
My lord, on his own account,
And
my
what
lord.
do you say about C? 17(1)(c),
My lord.
5C?
Works
Works contract where
Works
supplied
contract
for
service when
construction of
supplied
an
for
immovable
construction of an
property,
immovable property,
except where
when
it is
necessary, except where it is an input service.
input for further supply of
Works contract, my lord.
contract. That is different. That is another thing. Just for example, I am making the works contract by myself, and then there is another person concerned from whom I am getting the supply. That person would not get the benefit of input rate because he is supplying it to me. But I, after taking it, I make the works contract. Then in that regard, the 17(1)(5)(c) will apply.
My lord, in my understanding, my lord, the
Don't make it
GST
further more complicated.
my lord,
Mr. Goswami.
GST paid on goods and service used as input in execution of work contract. Input tax credited credit restriction under section 75C and 75D will not apply to the person as his output is works contract service, my lord. That is what is held by, my lord, the AR, my lord.
Who is that AR?
My lord, lordship may kindly come
Advanced
to
ruling.
my lord, section 50, my lord. Section 50, my lord.
Advanced ruling.
Yes, my lord.
Advanced ruling is for which purpose? Advanced ruling is for which?
Section 50 and 51, my lord.
Yes,
Applic-
what does it say? 50? Of which one?
my lord, the GST Act, my lord, 2017, section 50.
CGST? No.
And the CGST, my lord, CGST.
No. 50 is different.
Oh, sorry. Sorry, my lord, section 96, sorry, my lord. Sorry, my lord. 96. Page, my lord, 78,
Subject to the-
subject to proper chapter.
So?
So, my lord, this is the authority, my lord.
Authority where?
My lord,
Which authority are you relying?
my lord, my lord, my lord, under this act, my lord, and
No,
this
no,
is under
which
this,
authority you are relying?
my lord, and my lord, what?
No, no, Mr. Goswami, which authority you are
My lord,
relying?
what it is said, my lord, in
No,
section
no,
96. my
forget
lord,
about
may I read?
that. Mr. Goswami, kindly come to the point. Which authority are you relying? Which advanced ruling authority you are relying?
No, my lord, I cannot cite the advanced ruling judgment here, my lord.
Understood.
My lord.
But that advanced ruling will apply only to that particular state.
Yes, my lord. Exactly, my lord. But my lord, this is a case, my lord, it cannot vary from state to state, my lord. This is a subject, my lord, it cannot vary from state to state, my lord. This is a subject, my lord. If my lord, somebody is getting ITC for my lord service contract in the Andhra Pradesh, my lord, a person in Assam cannot be denied from ITC for the same service contract, my lord. My lord, that is my humble submission, my lord. Lordship may differ, my lord. May rule out, my lord, my submission, my lord.
But how? But that advanced ruling authority
And
is
my
in
lord-
respect to the state or union
Yes, my
territory.
lord.
But
That
how
is
does
why,
it
my lord,
apply?
that is not applicable to other state, my lord. It is, my lord, given here, my lord. It is, my lord, given here also, my lord.
Sure.
But my lord, thing is this, my lord. My humble submission is that, but if a person is getting, my lord, ITC on a service contract, my lord, in a particular state, my lord, if contractor giving a service contract in a different state, my lord, he cannot be denied the same benefit. Number one, my lord. Number two, my lord, here, my lord, from my lord, affidavit, my lord, it, my lord, shows that they are availing ITC, my lord.
Where?
My lord, may kindly see my affidavit, my lord.
Yes. that is
Annexure
the-
1, it starts from 259, my lord.
Yes.
My lord,
Pertaining to
bill
GST.
pertains to GST neutralization from above mentioned CA, my lord. This CA is, my lord, exactly the same CA, my lord. CA construction JI 2123 dated 31/12/2015, my lord. Lordship will find from the writ petition, my lord, it is the same contract agreement, my lord.
Mm.
Bill pertaining to GST neutralization for above mentioned CA is hereby sent for necessary vetting and passing the bill. Before make any payment, accounts department is requested to check all stuff, or it also thoroughly along with it, with taking advice from GST consultant engaged by accounts department, Maligaon headquarters.
Mm.
Now, my lord, the last page, my lord, 268,
260?
my lord. Last page, my lord.
Yes.
My lord, this is construction of the name of the work at the top, my lord. CA value,
What is the date of this communication?
the date 31/12/2015, my lord.
Then GST didn't come then?
No, my lord, not 31/12, my lord. This is the contract CA date, my lord. The date, my lord, it is after, my lord. It is shows that it is after, my lord, coming of
Where?
GST 17/2000.
Where is
My
it?
lord, I will show, my lord. I will
Where?
show.
Please show.
My lord, this cover letter itself is of 8/8/2019, my lord. Lordship mechanism. The cover letter 8/8/2019
Where is the covering letter?
at page 259.
259 is the covering letter.
Yes, my lord. And my lord, At two,
by month.
and my lord,
No. Covering letter contains 4 documents.
yes, my lord.
What are the documents? There is only GST reimbursement bill number 1.
This all against all these bills, my lord. My lord,
Mr.
the
Goswami, kindly
GST
come to the
neutralization-
point.
my lord,
Kindly come to the point. Here, where is this document is the covering letter of that?
my lord, I'll come to Lordship may kindly come to page 267. My lord.
267.
Yes, my lord.
What is the date? This is the.
My lord, this date is 1/8/2019, my lord, below, given by certain accountant, my lord.
Furnished by-
This is to certify that as per record produced information furnished by MS HCC CPL having principal place of business at so and so for works construction of so and so, so and so, so and so. The bill amount of the company after applicability of GST is as per the calculation in annexure enclosed. This certificate is issued on specific request from the client for release of their bill from the Northeast Frontier Railway Assam for the work mentioned above. This certificate has been issued based on the original document produced before us.
Yes.
So, my lord,
So what
this is
it?
the work, my lord.
Ah.
Work, my lord, and CA number is same, my lord. Construction JI
Okay,
2123
okay.
dated 31/12/2015, my lord. The
Hmm.
CA value was, my lord, 784 crores, my lord.
Hmm.
My lord, and my lord, sub CA, it comes around, my lord, this. The value is this, my lord. Now, my lord, they have calculated final agreement value. 1,028 crores, my lord. Final value, my lord. Less gross value of the bill pre-GST.
Hmm.
So and so. Agreement value payable after GST. So and so. My lord, excise duty is this. Net taxable liability pre-GST. This is, my lord, net taxable liability pre-GST, my lord. Tax post-GST, gross value.
Where? Ah.
90,
Number
95 crores, my lord. My lord, they have deducted the input tax credit, my lord. Next row, input tax credit, 31 crores, my lord. And now, my lord, net tax liability post GST, my lord, 64 crores, my lord. Now, they will get, my lord. Now, my lord, they are asking from the railway the 31 crores which they have received from, my lord, as, my lord, input tax rate, my lord. Railway is giving, my lord, them to 64 crores at the rate of 7%, 7.04%, my lord.
Hmm.
GST neutralization, my lord.
You are paying 64 crores.
My lord, it is at the rate, my lord, what they have said, my lord, last row, my lord, variation in balance is equal to difference payable total value of balance work X 100 at the rate of 7.04%, my lord. At this percent, they will get this, my
No,
lord.
no, railway is willing to pay 64 crores.
No, my lord, what they are, my lord, the percentage is, my lord.
Mr. Goswami,
My
kindly
lord.
let us make it very simple. The case which was there was,
My lord.
they were to pay to do a particular work at 100 rupees
My lord.
for the payment of the steel.
My lord.
And thereupon, this price has increased to 200. Now they are asking for the GST for this 200 rupees.
Yes, my lord.
Now you are saying that on account of input credit, he is not entitled to.
I am paying the increased price, my lord. They are asking for the
No,
tax
that's the
on the increased price, my lord.
increased price doesn't have a GST involved.
Yes, my lord.
Then
But they are getting input tax credit, my lord, after coming of the GST, my lord.
how?
And my lord, how I am
So
showing, my
how
lord,
they are getting?
my lord,
Show
they
me.
are getting, my lord,
No, they
are-
have to get as per this act.
my lord, they have to get it. But my
No,
lord,
show me from this act where
my lord, I'll
where the
go to the act,
authority
my lord.
categorically says that if they don't get it,
My lord,
Mr. Goswami,
My-
kindly don't make it further complicated.
no.
It is otherwise a simple thing
Yes,
which I have understood.
But my lord, from this letter, my lord, they have admitted that they are getting input tax credit of 31 crore 26 lakh. And my lord, if
Yes,
I-
Mr. Muzumdar. What is he saying?
this is their
I'm-
document, my lord.
First of all,
I don't know other things, but one thing Mr. Goswami is very good in confusing. Yes.
every day he's bringing new, at least he's trying to divert the issue. Issue is very simple.
And the issue is otherwise very simple.
Yes.
But only one thing this court will require,
Madam.
you file a reply to this affidavit,
Madam.
this additional affidavit. Huh? I think then you can very well explain.
Madam.
And also give a reference to this particular Annexure B, what is mentioned, because this is your document.
Madam.
Mr. D. Mojumdar, the Learned Senior Counsel, and assisted by Mr. B. D. Dekka. and Mr. G. Goswami appears for the relevance. An affidavit, an additional affidavit has been filed on 1/3/2023 by the respondent number 4. Taking into account the allegations made in paragraph number 3 and 4 of the affidavit, this court finds it, this court is of the opinion that an opportunity should be given to the petitioner for filing a reply to the same. Accordingly, how much time? 10 days time is therefore granted to the petitioner to file the reply. Let this matter be listed again on 20 April. Because this could otherwise
Alright.
tomorrow, today is 14, 10 days would be 24,
difficult.
24, 14 would be 24. Let us have it on 28th of March.
Well.
But Mr. Goswami,
Well.
from what I have got it,
Well.
from what the GST has said it,
Well.
this is a case which needs to be allowed unless we see something from the habit.
But the paper shows that they are
Don't make it
availing
further
RTC,
confusing.
and they cannot claim the amount which they are already getting. And if the GST Act is also clear about if somebody has getting ITC which they are not entitled, then they have to pay 20, they have to return that with 24% interest. That is also a fact.
Who is the authority to do that?
But, I am
No,
shown,
who is the authority to do that?
very well,
Who no, Mr. Goswami, who is the authority to do that?
This GST Council,
Mr. Goswami, kindly, who is the authority to do that?
the AR is the authority.
No.
AR is
No.
the authority,
Who is the authority to impose fine and penalty upon them?
the GST department.
Let them
No
do
doubt. But the AR
Let them do it.
AR is the authority to decide whether they are entitled to ITC or not.
Now,
This is
whether the AR have decided in the case in the state of Assam,
no.
then
This may be sent to my AR,
Why?
This is on because it is the by treated by the state of
where show me that. Don't come up with making all this statements. Where is it?
Section 96 subject to correction. by
Section
your
96 says what? What does it say?
subject to the provision of this chapter for the
Mr.
purpose of
Goswami,
this.
kindly don't make all this unnecessary submissions.
Mal.
Limit yourself.
Mal.
You are on live streaming nowadays. Court number 18 is live streaming. Don't make these submissions. What will your client tomorrow think about?
Item 3 to 16.
Obliged.
Yes.
Lordship, this matter has been fixed on 21.
No, it was never fixed on 21. Who says the matter was fixed on 21? Because of the fact that I was
lord.
hearing
My
the
lord,
meats of the
otherwise-
matter.
Otherwise.
And on the last occasion when the matter had come, this was not within the contemplation of this court at that point of view. I said it was on next Tuesday.
My lord,
And from Thursday to next Tuesday is today.
my lord, otherwise we have prepared the list of the impugn orders.
No, if you want an accommodation, this court is very happy to give you accommodation.
My lord,
You want an accommodation?
no, my lord.
Then, Matthew? Yes. Mr. Dotto
Yes,
doesn't.
My lord, before going to,
You
all
see,
the
the
other
matter
facts.
has been heard.
my lord,
Only thing is, the question therefore is, what is this order of in WPC number 748? Where is that order?
747, my lord.
747 or whatever.
Yes, my lord, 747 of the petitioner. my lord.
Yes, where is that?
That is page number 69, lecture
Huh?
9 of, page number 69, my lord,
Page
Annexure 9.
69.
of my petition, my lord,
69.
annexure 9, my lord.
Yes. What is that order? Relevant paragraph of 20 read the upheld by the Now the petitioners got the benefit in pursuance to this order,
My lord.
and thereupon, and this court is of the district.
The implementation order is at 373, my lord.
Let us read the office memorandum of 1998. I think this will also, this is the main issue. Problem arises because of this, no? Isn't it, Mr. Counsel?
My lord,
It is this office memorandum which is, now let us read that. We will find this, I think, the office memorandum out here in the 2011 SCC online essay, Guwahati 134, the division bench judgment of Justice Anima Hazarika and B.D. Agarwal. This is the entire thing happened because of 22/1 to 1998.
my lord.
You have that?
Actually, yes, this judgment is not with me, my lord.
Mr. Datta, you have it?
Yes.
Mr. Datta, what do you mean by this
Yeah.
HC?
That is why, my lord. That is why, because of this memorandum, my lord.
Huh,
when it
everything
was
happened
given-
because of this.
Yes.
Now, what do you mean by HC?
Head constable, HC, head constable,
Concept.
Huh?
HC, my lord, head constable.
Head constable. Now, what has happened? These draftsmen, grade 1, grade 2, and head constable draftsmen were brought under one unified cadre and said that they will belong to this under the pay scale of 4,000 to 6,000.
Yeah.
Now, it is therefore the case of the petitioners out here, which have been upheld by the other courts also, that they are therefore entitled to be given the same treatment in respect to them. Meaning thereby that they were holding the rank of Havildar Cipher.
Yes.
And as such, they should be given the same with the ASI, if I'm not wrong.
I've given the pay scale at the pay scale. my
No,
lord.
that I've seen it. But what has happened is this, the problem arises because of this.
Internal para 3 of my PDB. On the pay scale.
Here, if you see, kindly come to Justice Besh judgment at page, internal page 66 of your affidavit, page 158. Now, the rank structure, paragraph 5, page 67. The rank structure and pay scale of Havildar Cipher to which the petitioners belong by notification dated 86 based on their technical qualification were fixed at class 1, class 2, class 3, SI, ASI, Havildar.
Yes.
This is the rank structure. It is stated that the recommendation of the Fourth Pay Commission was not fully implemented in the Assam Rifles, and instead the technical staff under Cipher from all the three classes were given the post and rank of Havildar with pay of 975 only. By the Gazette notification of the Fifth Pay Commission dated so and so, issued by the Government of India, Ministry of Finance, all the technical assist rank were redesignated.
Yes.
And the pay scale were revised in all paramilitary forces. The rank and pay of Havildar, ASI and AR were given to the technical combat stimulator, which is as under. So then this Havildar was given 3,200, 5,000 and 5,500. The petitioners contend that despite such recommendation of the scale by the Fifth Pay Commission, in respect of the central paramilitary force, the same was not implemented in the case of Assam Rifles technical staff, especially the Cipher. The petitioner who belonged to the signal and telecommunication were deprived from the legal rights to get equal pay for equal work. It is further stated by notification that this is the 97. The government of India rationalized the rank structure and pay scale of non-gazette cadres of Assam as follows: Constable, Head Constable, ASI, Sub-Inspector, Inspector, Subedar, Major. That pursuant to the declaration of the Fifth Pay Commission, the rank structure and pay scale from the rank of constable up to the rank of Subeda Major. Constable to Subeda Major, 1 to 6. Have been rationalized and stated in the notification dated 20. The said notification was forwarded to the Director General for University. The revised scale is here. Now you see from 3,500, 3,050 to 4,590. Now, if you see, kindly see, constable, head constable, ASI. All these will come under one thing in view of, if you see that 98 one. For example, the HC, head constable RF, will be governed by all combatants area. For example, in replacement of the scale of 3,200 to 4,000 as approved by the government in the said amendment. Now, what has happened? And emerging the pay of the commission has been given the replacement pay scale of 4,000 to 6,000 in respect to these three categories of posts in central Benue. These three categories may be designated as ASI. So what has happened? These 4,000 to 6,000. It is stated that since certain doubts were expressed by the Central Army in fixation of the certain non-gazetted personnel of the Central Armed Forces with effect from 20, the Government of India Ministry of Home Affairs clarified its wide office memorandum dated 22/1/98 that order dated 20 are equally applicable to all combat categories. Learned counsel for the petitioner contended that on the recommendation of the Fourth Central Pay Commission, Assam Rifles have been granted the revised pay and allowance entirely at par with the Central Armed Forces, but as the changes in the rank structure was not carried out in the Assam Rifles, like other Central Armed Police Forces, there is an apparent disparity in the service conditions of certain category of personnel, that is Havildar and Cypher. Havildar is where? Earlier there was no Havildar. The same notification here. Learned counsel for the similar questions came in writ appeal versus man. The state appeal was allowed and the Union of India was directed to give appropriate rank and pay to the petitioner of the state petition as per the recommendation of the Supreme. Agreed by the state judgment that the Union SLC was dismissed. While relying on the cases of one Havildar and the state, which was accorded in its favor by and pay certain recommendation Yes, I'm coming in fact. That is the only judgment which is there on record which has reasons.
Yes.
All other judgments are just following the other judgment. Now kindly come to this Union of India versus the nation KK. You have the judgment?
My lord,
2008 1 SCC 586.
586, yeah, looking for judgment.
You have it?
Tell that if the necessary materials on the basis.
Now,
Where-
Mr. Datto, do you have the judgment with you?
No, my lord, it is mentioned.
Do you have a copy of it?
No,
I have
I
one
don't.
only, but okay. 2008.
2082.
Give it to him.
Yes.
Kindly see paragraph 24.
Yes, my lord.
Yes, read it.
On the opposite
From the above expected paragraph.
paragraph of the counter affidavit and the resume
The
Of
resume
correspondence-
of the correspondence
reference
referred
to
to above.
above is clear, it stand admitted by the petitioner hearing that all the paramilitary forces, including Assam Rifles, are on a par with each other, and there was apparent disparity in the pay scale of the personnel of Assam Rifles with their counterparts in other central paramilitary forces. In order to rectify this disparity, and Director General of General Assam Rifles petition number 2 hearing by his letter dated 1998 had in fact taken up the grievance of the respondent with the Ministry of Home Affairs inter alia, recommending redesignation of Havildar RM grade 1 and 2 of Assam Rifles were as warrant officer for replacement of pay scale of rupees 4,000 to 100.
So this was the recommendation,
This is
and
the-
this was which was accepted.
yes,
So meaning thereby it is only a redesignation.
yes, my lord. Redesignation.
It is only a redesignation. It is not an upgradation. Then under what circumstances you are going to say this? Because this is the specifically in 1998, this was being done, and this is what has been held in by the Supreme Court. Kindly see thereafter in paragraph 25. However, the Ministry of
However, the
Home Affairs,
Ministry of Home Affairs filed later dated 3/3/1998 while accepting the state proposal had recommended redesignation of Havildar RM as a warrant officer, but subject to the condition that the pre-revised and revised pay scale of Havildar RM in other paramilitary forces were identical to the pay scale of Head Constable RM in CRPF and BSF. Manifestly, in the instant case,
then come to paragraph 27. Thus, the
There's a
short
short-
question requiring a consideration is whether, having admitted in their affidavit referring to herein above the apparent disparity and anomaly in the pay scale of radio mechanic, the administrative authority, the petitioner herein could be permitted to perpetuate apparent discriminatory differentiation in the pay scale because of the disparity in pre-revised and revised scale of personnel of the Assam Rifles prior to the recommendation of the Fourth Pay Commission, irrespective of the identity of their powers, duties, and responsibility with other paramilitary. In our considered opinion, in view of the total absence of any plea on the part of the union that the radio mechanics in other paramilitary were performing different or more onerous duties as compared to radio mechanics in Assam Rifles, the impugned decision of the government was clearly irrational and arbitrary and thus violative of Article 14. Now, therefore, the warrant officer from Havildar is just a redesignation. And if it is a redesignation, it is no financial upgradation or promotion. And this has also been held by the Meghalaya High Court.
My lord,
Because there was this affidavit, the contents of the affidavit has been quoted in this judgment in Dinesh. Kindly see here. Kindly come to page 595 of the judgment. That with regard to the averments made of the petitioner, in that judgment itself, 595 in the middle, that with regard to the averments of the petitioner made in the writ petition in paragraph 10 to 13, I beg to submit that on receipt of the MHA's letter dated 22/1/1998, that is that letter.
Yes.
Assam Rifles Directorate so-and-so dated 18th February 1998 had taken up a case with the HA to redesignate Havildar so-and-so as warrant officer and for replacement of the pay scale of 4,000 to 6,000 and to bring them at par with their counterparts in other central police organization. I submit that the attention of the MHA was drawn also drawn regarding placement of the Havildar so-and-so in the lowest scale of pay consequent to the implementation of the fourth pay commission. In reply to the Assam Rifles letter dated so-and-so dated Iman, the Assam Rifles Ministry had ruled out by the letter dated so-and-so that Assam Rifles can redesignate head constable as warrant officer if the pre-revised and revised pay scale of the Havildar in the Assam Rifles are identical to the pay scale of the head constable in the BSF so-and-so. I submit that the main hurdle in implementing the said order in the Assam Rifles is that there is a disparity in the pay scale of RM is
Radio mechanics.
radio mechanics in Assam Rifles and that of so-and-so. This has been held to be irrational by the Supreme Court later. The Havildar RM of Assam was drawing a pay scale of 975 to 1660 with effect from 86 and replacement scale was given as per the fee was 3,200 to 4,900 per month, whereas the CRPF so-and-so were getting a pay scale of so-and-so with replacement as so-and-so at 4,000 to 6,000. It is also pertinent to clarify that the qualification of head so-and-so is almost on the same part. Now, therefore, it is a case of redesignation. If it is a case of redesignation, as is apparent out there, then under what circumstances now you can say that these people have been given this? And it is on the basis thereof. The courts have been consistently holding that give them the rank and status. Wherever the petitioners have approached, you have given them. And therefore, in this judgment on 23rd of March 2017 by Justice Wedge, he made it clear that why all these petitioners have to keep on coming to the court for getting an order. Irrespective of everything, you have to give it. Now, this matter went to the division bench and then to the Supreme Court. And therefore, it has attained finally, and pursuant thereto, what you have done is you redesignate. Only see this chain of events.
One key, if I may add, my lord, as per the 3398 notification by the Ministry of Home Affairs, my lord, the redesignation was subject to if the pre-revised and revised pay scales were identical to the pay scales of their counterparts in BSF. And thereafter, my lord, in the same paragraph, it was observed that the pay scale of the Havildar was not same as that of the counterpart. So, my lord, that redesignation to the post of warrant officer was subject to the rider that the pay scale should have been same. And my lord, the
No.
Yes.
No, if that is being done, that will be in contravention to the judgment of the Supreme Court. You see, what the Supreme Court says, the redesignation has been done. It is an accepted thing.
Yes.
Thereby, the director of Assam Rifles categorically says that there needs to be a redesignation, but the only problem arises in view of the disparity.
Yes, yes.
Right.
That is the aspect.
Yes.
And this disparity was held to be arbitrary. That is there in paragraph number 27. That is what I read it.
But what the authorities have done, my lord, they have corrected that disparity by bringing that pay scale of 4,000 to 6,000, that warrant officer post. That disparity has been removed.
Understood. That has been removed because of this judgment in Dinesh. Because it has been held that this disparity cannot be the reason why these persons should be not given when everything is at par.
Yes.
That is what has been mentioned in paragraph number 27. Now, in pursuance to that, what you have done after this judgment came of the Meghalaya High Court.
Yes.
And after everything has happened, you have taken the decision out there to give them. Now, the only hurdle why you are saying that they are not entitled to this particular SCP or MACP culture is because a grade was brought in, which is an upgradation. And as such they were. But it is not an upgradation, it is a redesignation. In fact, that is why I was saying that Justice Vyas judgment is the only one where there is something. In all other judgments, if you see, it keeps on saying, and this is the answer is there in this judgment in Dinesh.
Yeah.
Because here he has, that is the specific. If you see kindly see the Dinesh judgment, kindly come to paragraph number 19 of the judgment. How it developed. Yes. No, 18 from 18.
The White Order dated
Ah,
10
by-
1997 passed by the
Asked
Ministry
in by
of-
Ministry of so and so, it was notified that the president was pleased to rationalize the rank structure and pay scale of non-gazetted cadre of Central Police Organization. And a result of this exercise, certain ranks were to be merged and the rank structure was communicated in the order along with the revised pay scale and replacement pay scale. Copy of this order was sent to all paramilitary on 22/1/1998. That is the main thing. An office memorandum was issued by the Government of India Ministry of Home Affairs by way of a clarification. In the said letter, it was clarified that the order is equally applicable to all advertised category. In the said letter, direction was issued to the read for with regard to the redesignation of 3 posts, including head constable, RM as ASI in the central parameter, along with their replacement pay scales were also ordered. It appears that the disparity in the pay rank and pay in various central militia could not be resolved on so and so, and the director of Assam Rifles submitted a report to the government with regard to progress on the pay scale. Paragraph 4 of the letter is so and so. Having failed to receive any positive response from the government, one of the radio mechanics issued a notice of demand to the Ministry of Home Affairs and the Director General of Assam Rifles, inter praying for giving effect to the office order dated 10/10/97 and the office order, office memorandum so and so. By the order dated, the Ministry of Iman informed the Director General of Assam Rifles that his proposal has been examined in consultation with Ministry of Finance, and it was found that there was no point for comparison of grades and scale of pay for such posts across various paramilitary forces. It was stated that the proposed upgradation may disturb relatives of various trades and grades within the Assam Rifles, and there was no functional justification for upgrading these posts. It is evident that on rejection of the recommendation made by the Director General of so and so, the respondents herein were left with no option but to approach the High Court for redressal. As noted above, the writ petition was opposed by the petitioner herein by filing counter affidavits for the sake of reference so and so. Now that is how it developed. It is a redesignation. So
what is the pair of the writ petitioner in 14250? 3 pair money.
Mr. Doctor,
And how
one thing is very clear.
It is clear,
A
my lord.
prayer made in the writ petition is one thing.
Prepare.
But if he is otherwise entitled to, on the basis of otherwise from the what have been stated in the petition, this court can give it. It is even the law as in CPC also, wherein it is the mandate that the relief has to be categorically mentioned. So the Supreme Court has been stating that it is not on the basis of the reliefs that the relief has to be granted. It has to be, the relief has to be granted on the basis of an overall reading of the entire plaint. Now, the second aspect of the matter, what is the prayer? Let us see. Then also, Mr. Doctor has said, so why should not? He is to admit call for the records, issue a rule upon so and so for setting aside the recovery of Iman and invention of the retired according to the petition of the plea, and to pass a further amendment of the to restore the correct basic pay as granted by the order dated so and so with ACP MSCP grant.
My lord, there are three pair, my lord. To continue, to not to recover.
Mr. Doctor, whose mistake it is?
My lord, how this excess
No, no,
money has
understood.
been
Whose
calculated?
mistake it? The learned lawyer. Should we penalize the petitioner for that? He has come up with all the. Now, why are so many petitioners here? If only the relief sought for is only for respondent petitioner number 2 and 3.
My lord, in respect of the other, no recovery order was issued on the date of filing of this petition, my lord.
Which are the documents you are challenging here? Annexure
Annexure 20, my lord.
18 and 19.
18, 19, and 20, my lord.
18, 19, and 20 is what? Recovery.
Recovery, my lord.
18, 19, and 20. Now tell me another thing, Mr. Doctor, what I'm saying is, have you put them into notice at the time of giving them the MACP or SCP that this is subject to the decision which is to be taken out there?
Well, in WPC number 403 of 2014, they paid for MSCP, SCP benefit as per the recommendation of the commission. It was allowed, and this was moved to the Supreme Court, my lord. In 2017, it was dismissed, and accordingly, the government of Assam or government of India.
Which item? Item number which one?
This is your
First item, my
Oh, 403.
lord. At
403 is the judgment of.
No, I'm holding 1425.
Yes, my lord. In this affidavit, they are referring the judgment.
1425, my lord.
They are referring the judgment of Honorable Justice.
1425.
Justice Vyas.
Yes, my lord. They are
Okay.
referring.
Yeah.
1425. After dismissal of SLP, my lord, the government, central government has issued in compliance of that order.
Where?
At page 174. Internal. Annexure and
Yeah.
in compliance with common judgment order dated 23rd March 2017.
Page
of
1?
Annexure N, my lord.
174
Annexure N.
and
174.
174.
Yes.
in compliance of order, my lord. In compliance with common order, judgment and order dated 23 March 2017 of the Honorable Court of Meghalaya, Shillong Ministry of Home Affairs, dated 30/9 2018. This Directorate A branch per section order dated such and such. I am directed to convey the sanction of the competent authority for grant of first, second, and third financial upgradation under modified assured career progression scheme on completion of 10, 20, 30 years of service from the date of remuneration in the next higher grade pay as given in section 1 part such and such of the first schedule of the CCS revised pay rule 2008 as at dated session 18 September 2009 to the part mentioned in the appendix with effect from the date as shown against their names. My lord, the financial measure granted to the personnel as mentioned in the appendix under modified assured career progression scheme shall be final and no pay fixation benefit shall be accrued to them at the time of their regular commission. Order of financial arbitration.
Where is it?
This is my lord.
Where did you put into notice?
My lord, thereafter, my lord, at page, my lord, 184, my lord, annex O, my lord.
Hmm.
Annex O.
It's the
The
same thing.
competent authority has decided to grant the benefit to similar situated petitioners against WPC number 403 of 2014 filed by the Havildar Skipper Devang Bhatt and
It is the same.
same, my lord.
It's the same.
Order of financial arbitration under SCP is issued earlier are hereby cancelled.
Okay, because
is-
now you have given them the benefit under the MSCP.
In SCP, my lord, after all first financial arbitration after completion of continuous 12 years and second financial and MSCP under MSCP scheme 10 years, 20 years and that is why the calculation I have stated in para how this was calculated as exact amount, my lord.
Where?
My affidavit para 2 Roman 2, my lord. Roman 2, my lord.
Yes.
Page 3, my lord.
Hmm.
That with introduction of warrant officer FIFA rank with effect from 10/10/1997 in accordance with the judgment and order dated 23/3/2017 dated for granting of SCP MSCP have been changed as upgradation to the rank of
Oh,
warrant
Mr.
officer.
Datta, you are repeating the same thing. It is the same thing. First of all, this court as to whether the warrant officer was an upgradation. It is not an upgradation, it was a redesignation.
Excess amount, the cause of recovery is there, my lord. Because of
The cause of recovery is once you hold the warrant officer to be an upgradation, obviously he will be entitled once upgradation one is already there. Means the second or third, it has to stop by if you hold the warrant officer out there, then it has to stop at the Subedar Cipher, the third.
Yes.
But if you don't hold the warrant officer to be first aberration, then it will be Subedar Major.
Yes.
That is your case. The entire case, the entire dispute involves as to whether the warrant officer was a redesignation or not. Now, if it is a redesignation, then it cannot be a case of upgradation. And if it is not an upgradation, then they will be entitled to 10, 20, and 30. You see, the difference between the ACP and MSCP, I don't know, it's subject to correction. ACP had 12 and 24. So every 12 years, if there is a person doesn't get sick, so you'll be given a financial upgradation. to the next higher grade. And 24 years. Now, the government later on found it, instead of this 12 or 24 years, let's make it 10, 20, and 30. So therefore, this 10 years was given, 20 years was given, 30 years was given. Now, therefore, a person who have earlier got somebody must be working for, just for example, 30 years. He must have got to financial upgradation in view of the SCP. That you have cancelled it to give him now 10, 20, and 30. Isn't it so? Now,
It is a-
tell me, where have you put him to notice? If you have not put him to notice, then how can you make a recovery in view of Rafiq Masih?
My lord, actually, earlier, my lord, the calculation before introduction of warrant officer between this cadre post, my lord. the-
There was no introduction of warrant officer, it was redesignated.
Yes,
What you have done is, you are still having this Havildar cipher. In view of the 2022-1-1998, the Havildar cipher has already amalgamated with warrant officer. If you see that, that is the reason why that Havildar grade 1, grade 2, and HC or something to that effect, there were 3. They have been all done into warrant officer or ASI rank.
yes, I agree.
Which is made clear. Now, Mr. Gupta is going to come up and say that there are 1400 people who have got benefit.
No, my lord, I will continue. My lord, I would like to reiterate that point only. That
No, Mr. Gupta, kindly
my lord,
leave something for the appeal.
yes, my lord, and in
Leave
continuation,
something for the appeal. No, only one thing I want to know is, did you put them to notice before making a recovery?
notice, my lord, is not there, but undertakings are there, my lord. In few cases, they have submitted the undertaking.
When?
That in case of revision of pay, my lord, that in my case, my lord, there is an undertaking.
For what?
Undertaking given by the petitioner that in case recovery is made in when the pay scale is revised, if there is any excess amount, that can be recovered from me.
When? Before retirement? Which matter you are referring to?
My lord, in my petition.
But if we answer the first question,
Yes,
that it is a redesignation, then the question doesn't arise.
my lord, in terms of this 22-198, my lord, the carrying out the redesignation could only happen if there was a disparity. If there was no disparity in the pay scale of cipher with other CPU. And since there was a disparity, my lord, to bringing redesignation, my lord, the ASI post was introduced. The warrant officer cipher post was introduced. My lord, that is correct that, my lord, the introduction of the warrant officer post is a redesignation, but to implement the order of the Meghalaya High Court and, my lord, in terms of the 3398 notification, wherein the ministry has clearly stated that that can be implemented if the pre-revised scale is identical to the pay scale of the counterparts, and that pay scale was not identical. So, my lord, that ASI rank was introduced to bring it par, and therefore, my lord, so that decision, my lord, it can be as my lord has.
You need to seek a review
My lord.
to the judgment of the Supreme Court in Dinesh. Then I will hear you. But prior to that, let me dispose of the matters.
My lord, undertaking is 36. At
Page?
page 36, my lord.
In the first case.
Where is it?
You know,
Page
All
36.
36.
1325.
One,
The first
one
writ petition.
first
my lord.
week. 1 to
1425.
Yes, yes.
yes,
Page
page 36, internal 142.
36. Yes. Hereby
Yeah,
elect
and-
to continue as the pay vendors of my substantive payment before until the date of my next increment, when I hereby that in the event my pay has been fixed in a manner contrary to provisions contained in this code, as expected
undertaking is
Will be
Okay,
refunded
bottom line.
by the- So similar will be there for everybody.
My lord, this undertaking was given when I was promoted to the rank of Subedar. It's the 1st July 2014, my lord.
I vacate or cease to draw in the existing to ensure the date of my promotion.
When
or
I was
elevation
promoted
in
to
the
the rank
post
of
post of Subedar site.
Subedar Cyberman. And the benefit was came as per the Annexure 11 and 12 of my writ petition. my lord.
No, let us come to page 37. There is no, it is only on the case of, this is not a case of here. This is increasing. But anyways,
Sir, my
these
lord,
are already there.
16, my lord.
So let it be there.
because of as per the judgment of Honorable Haryana, Punjab and Haryana High Court and versus Jagdish, the personnel are bound by the undertaking.
I hope. Out, Mr. Your name?
V. Kumar, my
Went to the learned council. We are segregating the content matters out, huh? And where is that list I've asked you?
Yes, my lord, we have prepared, my lord.
What is this?
Recovery bound by the undertaking.
This was something which was brought in after Rafiq Masi. When there is a, what you call, they have been put to notice. But that is, if you see in these judgments, if we look into this judgment, it is also clear that at the time when the undertaking was given, that he was said that you are being given only this for a particular period. But if something happens to this litigation or something, if I see here, paragraph 9, the submission of the respondent which found favor with the High Court was that a payment which had been made in excess cannot be recovered from an employee who had retired from the service. This, in our view, will have no application in a situation such as the present, where an undertaking, you see the word, was specifically furnished by the officer at the time when his pay was initially revised, accepting that any payment found to have been made in excess would be liable to be adjusted. While opting for the benefit of the month pay scale, the petitioner was clearly on notice of the fact that a future refixation of revision may warrant an adjustment of the excess payment if any made. But this was on these facts. You see,
Rafiq Masi case was in a without matter.
you kindly see this, para 2. The facts are in a narrow compass. The respondent was appointed as a civil judge junior division on so-and-so and was promoted as additional civil judge on in the judicial service of the state. By notification dated, a pay scale of the month was allowed under the Haryana supervision. Under the rules, each officer was required to submit an undertaking that any excess which may be found to have been paid will be refunded to the government either by adjustment against future payment or furnished an undertaking and was granted the revised pay scale and the selection grade. While opting for the revised, the respondent undertook to refund any excess if it was so detected and demanded subsequent. The revised pay scale of the law was allowed to the respondent on 20. The petitioner was put under suspension on demand and eventually was compulsory. In the meantime, the so-and-so accepted the recommendation of the first 3 months. The so-and-so was notified. In view of thereof, the pay scale of the judicial officer was once again revised with effect from 1/1/1996. An exercise was undertaken for adjustment made to the officer following the notification of the revised. On demand, a letter for Now tell me here, in this case, do you give an option to him to accept the revised scale or this higher scale?
But not given, my lord. Not given, but
Then does he
Yes,
have
sir.
an option? You
Because
kindly
of-
see paragraph 11 of the judgment, what you are referring to. In the present case, the officer to whom the payment was made in the first instance was clearly placed on notice that any payment found to have been made in excess would be required to be refunded. The officer furnished an undertaking while opting for the revised pay scale. He is bound by the undertaking. Anyway, this court is not going to those. Heard Mr. So and so, the learned counsel appearing on behalf of the petitioner. Petitioners in the batch of writ petitions. And Mr. and also the central government. As well as the respondents herein are represented by Mr. A.K. Doctor, Mr. H. Gupta, Ms. P. Sharma, and Mr. K. Gogoi. You are also appearing? I hope the petitions are enough for them. Yeah, we find another three. Mr. U. Goswami, Mr. Huh? B. Deka, A. Gaya. Seniority is a You are also there. No, contempt I'm not segregating because contempt is, let it be taken by the Chief Justice. Chief Justice is taking up contempt matters. The issue involved in the batch of writ petitions is as to whether the petitioners, whether the respondent authorities, by treating the post of warrant officer cipher as to whether the respondent authorities, in view of the creation of the warrant officers or post of warrant officer cipher, can treat the same to be the first financial upgradation to the petitioners. And thereupon make recovery from the petitioners on the ground of excess payment being made upon application of the modified assured career progression scheme bracket MACP. That's the question. To appreciate the dispute involved, it would be relevant to take note of the brief facts of the instant case. Resulting into the dispute, leading to the dispute. All the petitioners, Mr. Counsel, were all the petitioners enlisted as riflemen earlier?
Yes, ma'am.
All the petitioners herein were initially enlisted in the Assam Rifles as riflemen oblique ORL bracket operator radio line bracket close under section 2(4) bracket 4 of the Assam Rifles Act 1941. What were the rules at that point of time? What was the rules?
There was no rule, my lord. Only Assam Rifle Act 1941 is there.
But why you will say that the service condition of such petitioner persons, including petitioners, are regulated by the rules to be framed by the government in terms of, so it has not been framed.
No, my
At that relevant point of time when the petitioner were initially enlisted as rifleman oblique ORL, there were no rules regulating the service conditions of the petitioner. However, subsequently, the Assam Rifles bracket Group C combatized post bracket close recruitment rules 2000 was framed. The petitioners after rendering a service as rifleman ORL were remastered from rifleman oblique ORL to Havildar Cipher. At this stage, it may be relevant to mention that the Fifth Central Pay Commission had made certain recommendations relating to equivalence of rank and pay in all paramilitary forces. At that relevant point of time, the Assured Career Progression Scheme, bracket or ACP, for central government civilian employees in all ministries, public departments was also introduced as per an office memorandum dated 9/8/1999. In terms with the said scheme, it was decided to grant two financial upgradation under the upgradation to group B, C, D employees on completion of 12 years and 24 years of regular service respectively. However, the benefits of the said scheme was not given to the petitioners and similarly situated persons. On the ground that the remasteration of the petitioners and similarly situated persons from the post of operation radio lines to Havildar cipher was treated as promotion in the career of cipher. Under such circumstances, one Abdul Bari approached the Shillong bench of this court, as it then was, by filing a writ petition, which was registered and numbered as WPC number 256 SH/2012, thereby praying entirely for quashing of the decision of the respondent authorities that remasteration would be counted as upgradation for the purpose of grant of benefits under the Assured Career Progression Scheme and the Modified Assured Career Progression Scheme and that the first upgradation granted under the Assured Career Scheme, granted under ACP, to the petitioner therein would be counted as the second upgradation. In the meantime, the Meghalaya High Court was established during the pendency of the said writ petition. By the judgment and order dated 10/4/2013, the Meghalaya High Court disposed of the said writ petition with a direction to the respondent to grant the second financial upgradation under the modified MACPS on completion of 20 years in service as Havildar Cipher with effect from 2011. And the first financial upgradation should be from 2011-2003 with consequential benefits, and the order impugned therein dated 12/7/2012 was quashed and another order dated 7/10/2009 was modified to the extent that the first financial upgradation should be with effect from 2011-2003. In paragraph number 12 of the said judgment, the Meghalaya High Court had categorically held that the changing of the trade in the cipher category, that is Havildar cipher, through remasteration, is not a promotion and also not a financial upgradation. And therefore, counting of continuous service for the financial upgradation under the ACP scheme should be from the date of remasteration to the lowest rank of cipher category, that is Havildar cipher, on 2011-1991 as in respect to the petitioner therein. This order, this judgment passed in WPC number 256 SH/2012, dated 10/4/2013, was challenged in appeal which was registered and numbered as writ appeal number 30/2013. By then, order dated 18/11/2014, taking into consideration that the judgment dated 10/4/2013 was complied with, the writ appeal was dismissed. It further appears that a challenge was made to the order passed in writ appeal number 30/2013 before the Supreme Court, And by an order dated 4/9/2015, the special leave petition, bracket C, number 13534-13535/2015, was dismissed. It further appears from the records that the Directorate General of the Assam Rifles on 18/1/2016 complied with the directions passed in the order dated 10/4/2013 by an order dated 18/1/2016 thereby granting the financial upgradation to the petitioner therein. As the order, as the respondents, Assam Rifles, had limited the benefit only to the selected petitioners, who had approached the court to the petitioner, to the persons who approached the court. Similar writ petitions were moved before the Meghalaya High Court. Whereupon similar orders were also being passed. On the basis of such similar orders, those persons were granted the benefits under the Assured Progression Career Scheme and the Modified Assured Career Progression Scheme. Okay, I'm coming again, huh? Just for grazing ground,
Or
roadside lands,
Or reserve.
or reserve,
Reserve for,
there cannot be a settlement.
there cannot be settlement.
Supreme Court in various judgments have held that such settlement, in spite of being done by the authorities concerned, is divorce the rule.
Reverse the rule. Yes,
And
that
as such settlement cannot happen.
cannot happen.
Now you have to incorporate that idea. And that is why at that point of time, when the rules stood, it was categorically mandated then that there is no question of any adjudication at all.
Yes,
Because these are these lands which under no circumstances a person can have a settlement.
Yes.
Or it can be settled also.
yes,
Question of settlement doesn't.
it doesn't correct. Because
Now
it is-
what has happened? You now brought in the wasteland.
yes, Yeah, Westland is there.
No, earlier Westland was not there.
Yeah.
Therefore, if you see all the decisions prior to 1997,
Hmm.
the concept of Westland was not there. And most of the challenges which were made at that point of time were challenges pertaining to that these are wastelands, and as such, this does not fall within the ambit of grazing grounds,
Yes,
road reservation,
right.
or reserved land
Yes.
which is there, and as such, you cannot initiate the proceedings under 18.2. Online objections.
Yes, online. In fact, division benc's decision is also there, I would say, my lord. I have checked it out. That
So
is
all
very decision.
line of decisions were there.
Yes.
Now what has happened is you brought in the Westland.
Westland. And
Now
all-
Westland, therefore, he has a right to show a bona fide claim.
Yeah.
But how can the authority decide? Can the authority under the revenue board? This is a revenue authority.
Revenue authority.
The revenue authority cannot decide the bona fide claim.
Now, yes, I will be addressing this court, my lord, on the issue of bona fide claim. Now, here, my lord, I will have to call out my case.
No. Why do you need to?
So, because,
If we incorporate that idea
my lord,
of Justice Bhuyan and Justice Suranajan, wherein it says, where the question was as to why a proceedings under the civil law, the normal civil law should not be taken, and why these particular proceedings have been initiated. Because here it's a faster mode. You are to dispose of land grabbing proceedings within 6 months normally, and it may go to 1 year, and you have to give reasons for that. Why that? Then, when the reference was made, it was taken note of by the division bench that look here, he has a right to apply before the court. He has not done anything. Now he has to bear the brunt and have to now satisfy that he has a better claim than the petition.
yes. So therefore, my lord, the foundation is his bona fide claim. If a person, if that aspect of that matter, bona fide claim is not there, assuming, then, my lord, there is no necessity, my lord, of bringing around all these provisions of law. So here, my lord, if we go, my lord, by the scheme of the, my lord, provisions in Rule 18, prior to that, my lord, Rule 16 specifically prohibits. Rule 16, Lordship will kindly see, and Rule 16 is codified, my lord, by the Honorable Apex Court, my lord, in the decision of Radha Kanu. Radha Kanu, Lordship is well aware. Rule 16. But I am reading it, my lord, from the settlement rule.
This is what
Yes.
that day I was looking into.
It is
This
Rule
is the
16.
provision.
Rule 16.
Yes, a person cannot otherwise enter
Enter. So there is a-
without a lease.
without the leave. Now, Rule 16 says, lease issued on written application only. Lease shall be issued on written application only, and no person shall enter into possession of wasteland in any area until a lease has been issued to him, or otherwise a written permission by the deputy commissioner has been granted to him, pending issue of such lease to enter into possession. Now, this is the opening provision of, my lord, so far as Rule 18 is concerned. Now, there is a specific bar. There is a specific bar created under the provisions of Rule 16, prohibiting a person from entering into government land. Otherwise, my lord, if he is specifically have been permitted by the deputy commissioner by an order in writing, or otherwise, my lord, he
Now
has,
the deputy commissioner's permission cannot also happen
yes,
because it has to be, if you see Rule 1,
yes.
it says it is subject to special orders of the government.
Government, yes, definitely. So here lease would, my lord, definitely inevitably mean, my lord, issuance of a patta. Lease means patta. So unless and until, and patta means it is settlement, my lord. Unless and until, so therefore, my lord, post 1997 after amendment, these aspects of the matter has been brought in, my lord, in Rule 18.2. Lordship will kindly now come to Rule 18.2, my lord, for a moment, my lord. I'm troubling my lord with all these rules again and again. Rule 18.1 says, subject as hereinafter provided, the deputy commissioner may eject any person from land over which no person has acquired the rights of a proprietor, landholder, or settlement holder.
Hmm.
In that decision, my lord, which my lord is holding up right now, my lord,
Which
that-
one?
that decision, my lord, of that honorable division bench.
Division bench.
Yes, that
Hmm.
was a my lord decision which was decided in a writ appeal.
Hmm.
My lord, the land reserved for Guwahati University was encroached by the writ petitioner.
Hmm.
He filed, my lord, several writ petitions from time to time.
Hmm.
He was in occupation, my lord, for a continuous period of 25 years. And my lord, he has raised constructions therein. And finally, my lord, the honorable single bench of this court, my lord, dismissed the writ petition. Against that he went in appeal. He raised the claim of my lord bona fide,
Hmm.
that he bona fide requires that land. That plea was negated by the my lord division bench. I'm relying on that decision, my lord, to bring home my contention, my lord, that bona fide claim, my lord, that as it appears here is not, my lord, a mere claim. That I have been residing in the government land for over a prolonged period of time. I have raised constructions. Everything was known to the government. Now the government cannot just summarily eject me. At page, my lord, running page 5 of that, my lord, internal page 5 of the decision, lord, triple five. So therefore, bona fide claim, it will only rise, my lord, if there is any right accrued to the person who is in wrongful occupation of the government land. Because,
So who is to decide?
my lord,
Who is to decide that?
The-
Who is going to decide that?
now since, my lord, the petitioners are before this honorable court, my lord, the materials are here before this honorable court, they will have to, my lord, justify before this honorable court, they will have to prove that they have a right to enter. If they do not prove, they fail to establish, they do not have a right, that they have a right to enter into the land, government land, notwithstanding the provisions of Rule 16, then definitely, my lord, will interfere. Then, my lord, the issue of bona fide claim will
No.
come,
What he said
my lord.
has to be unflinching. You can't go into any disputed question of fact.
So therefore,
Therefore I'm saying,
Yes.
it is under 226.
226,
So under such circumstances, how can this court decide
my
if
lord.
it is not unflinching?
No, because, my lord, lordship will
The
kindly,
only way out is he has to file a suit.
yes, he has to file a suit. Otherwise, my lord, the apex code is dictum is there, my lord. Apex code, I have found out one decision, my lord, where it says, my lord, there, my lord, that was the issue with regard to Rajasthan. My lord, in Rajasthan, my lord, a particular plot of land which was reserved for government land, a person came into occupation of that land, my lord. And, my lord, the government, they collected land revenue. So by way of collecting land revenue, my lord, a right to accrued in favor of that petitioner. Supreme Court says that it is settlement. You have given settlement. So therefore, his right has crystallized in his favor. So therefore, you cannot just summarily evict him. That is with regard to bona fide claim. So I have a claim, bona fide, to remain in occupation of that plot of land. Because now the issue is of occupation.
No,
Settled.
tell me, let us assume.
Right.
Here the Muzata out here takes the review.
Yes.
Can you say that the right is accrued upon?
Radha Kanu prohibits. Radha Kanu says, my lord, that no right.
Obviously, it
because-
cannot be.
Yes, there cannot
Because,
be.
and if you see on all other places, more particularly in the tea garden area, it is said to be a Tozimota,
Tozy. Tozy
which
my
means
lord,
it's a
penalty.
government revenue, but has been accepted in default to that effect. But the right of the government still remains.
Yes, yes. Tozy means, my lord, it is a penalty. I am in wrongful occupation, therefore I am paying penalty, I am paying fine to the government. Government is taking fine, but somehow government
It's
is.
not actually a revenue, but it is a penalty.
Yes, revenue, land revenue, my lord, will come only after issuance of a patta. Who is paying land revenue? A pattadar, or on behalf of a pattadar. So therefore, if no patta is issued to the petitioners in respect of the land in question, here it is, my lord, precisely Dag number 97, then, my lord, there is no right.
Yes, Mr. Dor.
Lordship, if your
If
lordship
there is
comes to
no
the,
right,
comes to the affidavit filed by the deputy commissioner on 1st of March 2020.
No, who are you? Who are you?
First of all, this is the land is beyond TB hospital law.
Huh?
Land is beyond TB hospital. That is has been stated
No,
by the
it's
deputy
okay.
commissioner.
Are you in area? Are you staying in an area which is a government land?
Yes, admittedly, it is a government land.
Okay. Okay. Now tell me, what is your basis of staying there?
Because we are landless.
Huh?
We are landless.
So,
Therefore, we occupied those land
no, if a person is landless, he can occupy.
as per land policy. Of
What does it say?
It states that if a
That
person is
person
occupying
who
land
is in, who
for
is
15
otherwise
years,
landless can occupy government lands.
there are provision is there of
Well, let us
1989.
see, let us see. Let me also be enlightened that till now, after so many years of practice, I didn't have it. This needs to be enlightened when I take civil bench 1. Yes, where is that land policy of Assam? এখন আছে ন সৰু কিতাপ এখন?
Yes,
Yes. এখন আছে সৰু পাতলা।
In
না,
fact,
এটা-
in fact, lordship will kindly, yes, if lordship is taking the land policy,
Let me have a look.
land policy of
Because
2000.
all along I have heard that a person may have a right, but another thing which bears in mind as to whom settlement should be offered. Tell me.
To whom settlement is to be offered. There, my lord, the scheme is laid down here.
No. See the regulation.
Yes,
Ah.
1989,
32.
land policy of 1989. If your lordship is taking this,
Settlement officer shall offer the settlement to such person, if any, as he finds to be in possession of the estate.
Yes.
How?
possession, if any, but then, my lord, possession of an estate, it depends again, my lord, on the prerogative of the government,
Understood.
my lord.
Which isn't this contrary to 16?
Yes, contrary to 16.
See this language at 32.
Yes, yes, regulation 32.
Because the regulation will, the settlement officer
Yes,
shall
the
offer the
settlement
settlement to
officer-
such person, if any, as he finds to be in possession of the estate and have a permanent, heritable and transferable right of use and occupancy in the same, or to be in possession as mortgage. If the settlement finds no person in possession as aforesaid, so this 32 will only apply if you are already mutated
Yes,
as per 50.
yes. So therefore, here, my lord, will see-
Okay, Mr. Dhar, kindly let us
No,
look into
no,
the
civil-
policy of
yes.
government, where is it?
land policy of 1989, Lord.
because
89,
Lordship.
not now.
It's amended in 2019.
Land
Lord.
policy of 89, yes.
So 14.3, Lord.
Huh?
At page 34, the
PL
lordship is holding this.
Page
Page 34,
34. Okay,
regulation 14.3, Lord. 14.3,
14.3.
Lord.
And within Greater Guwahati notified us that the government so and so maybe that payment of to meet with the indigenous persons of state in order of indigenous persons that is name or in the name have been in situation. Indigenous persons have been and will be that So have you applied for
Lordship, we have all applied for.
in 19 till when?
Uh,
When did you apply?
In the present case, document item number 28.
Hmm?
In item number 28, we have applied. I have applied on February 2020, Lordship.
February?
20th day of February 2020.
Very well. Then we will go as per the land policy of 2019,
Lordship,
not the 89.
19 can be. Page 17. There are also 14.2 and 14.4.
Yes,
Page 17.
page 17. Page 17 is a part of 89.
And prior to that also we applied for.
When did you apply?
Here we have annexed Kobola,
Ah,
that is 20 February 2020 at page 18.
ah.
And interestingly, 2 persons were given patta lot.
Hmm?
2 persons in the same bag has been given patta. I have stated in my affidavit in reply. And
No, then they will do one thing. You acquire. Those are not petitioners here, na?
that those 2 are not in the topic because they have already been
No,
issued.
like now they are doing it for ginger. They are acquiring. You will acquire?
Proper another
Here, my lord, the persons who have already been settled with the land are not before this honorable court. Let us not confuse it, my lord.
So he was given eviction notice in 2020. Therefore, after he came before this honorable court, thereafter they have settled with the land with him.
So,
Our lordship, if your lordship comes to the affidavit filed by the deputy commissioner.
Hmm.
On
where is
1st
that
of,
affidavit?
1st of March 2020.
1st of March 2020.
And thereafter we have filed our reply also. If your lordship comes to page
Yes.
39,
Page
page 39, paragraph 7, 7 and 8,
page 39.
39.
This is your reply.
This is the affidavit filed by the deputy commissioner.
Okay. Tell me.
Paragraph 7, may I read, Lord?
Page 39. 39?
In my
Wait, let me find out here.
affidavit was
Hey,
filed-
government of
affidavit was filed by Sri Pallab
Page
Gopal
39,
Das,
yes.
IAS.
This is the recent affidavit file, na?
Yes, Lord.
Okay. Para 7.
Paragraph 7. That we-
Environment area, the deponent we mentioned that in pursuance the government order dated March. So the entire dark number 97 has 464.63 R.
Yes.
Now you have allotted some portion of land to somebody. At paragraph number 7,
Yes.
why?
But that answer, in fact, also I had called the officers to the chamber. I had a talk with them, my lord. But, if this land is specifically reserved for TB hospital, how come you could allot? Precisely, I put that question.
And they say, somebody asked him.
My lord, I cannot put it across the board on record. That is the difficulty.
Then
And if your lordship
Now-
comes to paragraph 8,
I read
Because
paragraph
at
8.
that, because at that time, there was no such definite political will, my lord. Now, since my lord,
His will was not there in 2021.
2021, it was my lord, to
The
some
will
extent,
changes with the chief minister or something.
Now, since my lord, the decision has been taken, my lord, to establish the second medical college and hospital over this plot of land, tag number 97.
When was it allotted to the TB hospital?
It was, my lord, way back, my lord, 69. Pardon.
Hmm?
69.
69. It's entire 463
Yes,
bighas.
yes, yes,
Huh?
yes,
R 463 R
yes.
64 R.
It will be, my lord, 34 bigha, 4 kotha, 12 lesa. 34 bigha, 4 kotha, 12 lesa. If my lord is taking up that affidavit, lordship may kindly come to page 45, the last page of that affidavit.
Hmm.
There, my lord, the present status. In minutes of the meeting held on 19/2/22 in the office of the deputy commissioner regarding allotment of land with second medical college Guwahati. List of members present, so the meeting was presided by so and so, so and so, so and so, decisions taken. Lordship will kindly see the decisions. Number 1, the members of the meeting discuss about the urgent need of a second medical college for better health and accessibility of the general public of the state. The nomenclature of land of TB hospital to be changed in the name of second medical college Guwahati. This is under process, what I am told, my lord, day before yesterday. Allotment proposal of land measuring so and so 4 bigha 16 lesa covered by DAG number 90 so and so approved by the PCL subdivisional land advisory committee subject to acquiring from. In fact, they are now acquiring land, my lord, from the land which was already allotted to Animal Husbandry and Veterinary Department.
No, this is allotment proposal.
Yes.
Allotment proposal is for whom?
For the second medical college, the allotment proposal of land covered by so and so is approved by the subject
What
to
allotment?
acquiring NOC. Lordship will kindly mark the words. So, an NOC from the Animal Husbandry and Veterinary Department. So therefore, this DAG number 90 is already allotted, my lord, to Animal Husbandry and Veterinary Department.
No,
Now
no, no, no. This is allotment proposal is that you want to distribute this land.
No,
See,
no.
number 4
No.
also. Allotment proposal of government land.
Yes, Lordship,
Measuring so and so.
covered by DAG
Under
number
Moja
90.
is approved.
By,
So that means you want to further give those lands to others.
no, it is for the hospital, for the second hospital. Lordship will kindly read, my lord, I'm reading it slowly. Allotment proposal of land measuring 4 bigha 16 lesser covered by DAG number 90 of village so and so is approved by the special subdivisional land advisory committee subject to acquiring an NOC, subject to acquiring NOC from the Animal Husbandry and Veterinary
We'll further
Department.
hear on Thursday. On that day, you also, Mr. Third, you submit before this court as regards what is the enforceability of the policy. Whether the policy is enforced.
Now, yes. now
Lordship,
in the
one thing, Lordship, here in this
2019 policy, specific provision with regard to allotment and settlement of land pertaining to the city of Guwahati has been, my lord, incorporated. I will.
I've read it.
Yes,
14.2, 14.3.
yes, 14.2. It is already.
I've read it.
Yes,
No, that I've read it. But then also there is a question of well, how is it impossible? Whether the policy.
it is not enforceable. It will depend on the, these are the broad parameters. Policy lays down the parameters. On the basis of the parameters laid down in the policy, the government will, my lord, take the necessary action. Of course, not in violation of all any other law. It will be in consonance with the law. Because these are the broad.
Understood. We'll hear on that day.
Lordship, in
Because-
the minutes of the
Reach the
meeting,
matter again on
DAG number 97 has not been mentioned.
why 23rd? Today is what? 15. Then today is 14, na?
14,
Yes,
14.
15.
My lord, if I'm.
I don't need to hear you. I have heard you.
My lord will
Eh,
kindly,
This is only for judgment on that day.
my lord will kindly accommodate me.
No, 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 no. Don't delay it. You see, these matters I have already given up my mind to that effect.
My lord.
Only you have to just show me that. I'll also look into it. But
Because-
today I have to rise at 4:10.
My lord, yes, my lord, I can,
Okay, one
because
thing,
on
Lord.
Thursday, my lord, I will be out of station.
Not
That's why.
necessarily. Let your colleague argue. And Mr. Nath is there.
Lordship,
He is there very much.
one thing, Lordship, in this minute of the
Can it
meeting,
be on
DAG
Friday?
number
no, no.
97 is nowhere, Lordship.
And I'll pass the order on. No, I've got your point. It is only the question of enforceability of a.
Yes.
Because what is otherwise, to my knowledge, it is not enforceable. Because the policy is not enforceable through the court. They have a right. It is if there is a violation of Article 14, then the question would definitely look into.
Absolutely, absolutely.
But to enforce the policy, it becomes very difficult. That aspect, that is why I have asked Mr. Dhar to submit on that.
Yes,
If it is
lordship,
so.
lordship will kindly,
Look
lordship,
into that judgment in Hero Hondacom or something, 2023 one. What does the Supreme Court say on that?
and lordship, my respectful submission, of
Yeah.
course, this will be like my last leg of argument, my lord. But post 1997, all the decisions, prior to that, my lord, definitely, my lord, bona fide claim, all these things were there. Post 1997, lordship will find, my lord, this honorable court has not given any leeway,
It's
my
the
lord, to
matter
the
on,
adversary.
yeah,
Yeah,
16 as the first time.
my lord, this Sundargaon anti-eviction committee.
You ask Mr. Nath. Mr. Nath, you be present in the court.
And so. Very much.
Medical.
মই কোৰ্টৰ পৰা গৈ আছো ৰবা গৈ আছো এতিয়া বহুত দেৰি হৈ গ'ল ৰবা এক মিনিট ৰবা মই গৈ আছো ৰবা এক মিনিট
মানে মই কলিকতা যাব লগা
ফটো লৈ গৈছে ছাৰ
হেৰি
নহ'লে উপায় নাই মই ঘৰত গৈ চাম তেতিয়া মই হেল্প কৰিব পাৰিম তেখেতক এইটো কাৰণে কিমান তাৰিখ দিলে আমাক
এতিয়া মোৰ লগত নাই সেইটোত মানে যদি পকা লাইন হয় তেতিয়া নোৱাৰে
ইয়াতে এইমাত্ৰ এটা কথা ক'ব এইমাত্ৰ এটা কথা
পকা লাইন হ'লে তেনেহ'লে নোৱাৰে।